Thank you for joining us today for CILA's 6th annual Roundup training. My name is Victoria Mora, and I am a managing attorney at the Children's Immigration Law Academy, or CILA for short. As a brief intro to who we are, CILA is a project of the American Bar Association. We are a legal resource center, a capacity building organization, and a primary reason that we do this work is we think that every child should have representation. CILA is based in Houston, Texas, but we offer assistance nationally. We provide technical assistance regarding case-specific questions related to children with immigration cases. We offer quarterly working groups to provide spaces for advocates to collaborate nationwide. And we provide trainings such as this one and written resources. We also host a platform featuring pro bono opportunities across the country and resources related to pro bono. A lot of the CILA team is on today. CILA, y'all want to wave to everybody, and you'll get to meet most of us. As a capacity building organization, we are here for you. So if you need anything, please reach out to us. We call this annual webinar roundup because we will summarize the major changes affecting children's immigration law over the last year. Since there's been so many changes, we don't have time to go into a deep dive, but we will go over the key changes at a high level. We will include some practice tips, ethical considerations for litigating in this constantly changing environment, and as well as resources to guide you along the way. The webinar will go over the changes that have occurred since CILA's last roundup in December 2022. How many of you were here? Specifically, we will provide updates related to unaccompanied children in ORR, immigration court, prosecutorial discretion, SIJS and adjustment of status, crime and trafficking survivors, asylum and border issues, immigration policy and advocacy, and just as important or even more so, our team member Marisa will lead us through a centering and self-care exercise. After self-care, we'll open the polling for you to share your victory, and we will end with some additional updates and information about CILA. Lastly, throughout the presentation, we have highlighted several of our written resources in the bottom right-hand corner of the slides. We will be posting the links in the chat, and we hope you take time after the training to look them over. They are wonderful resources, and we're sure they will help you in your work. And now I will pass the virtual mic to my colleague Mireya to get us started.
Greetings, everyone. My name is Mireya. I'm one of the social workers here at CILA. I'm going to get us started with an overview of what we saw this past year in terms of numbers with respect to unaccompanied children. I'm also going to touch briefly on some key ORR policy changes, ICE's new young adult case management program. But let's start with the numbers and review them together. So in comparing the totals for fiscal year 2023 and 2022, the numbers were down by almost 15,000. ORR just wrapped up what they identify as fiscal year 2022 on September 30th, and there was a slight decrease in the percentage of youth arriving from Honduras and an increase in those arriving from Mexico by about 2%. So ORR has indicated that they will soon release fiscal year 2023 data, but we don't have that information just yet. Here on the slide, you see a comparison of fiscal year 2022 and fiscal year 2021. We don't anticipate huge variations this year, but stay tuned to the ORR website for that 2023 data. We do have current data indicating that as of December 8, 2023, there were 10,897 children in ORR care. And according to ORR's latest fact sheet from December 8th, there are still operating 296 facilities in 27 states. And as far as their latest influx care facility fact sheet dated December 8th, and we've linked both of those here, we can provide the following information about various influx care facilities nationwide. Pecos influx care facility transitioned to an influx site earlier this year, currently has 448 children, that is as of December 8th. DeMitt in Carrizo Springs has 210 children as of the same date. Fort Bliss is still on a warm status. There is no reactivation date. Greensboro in North Carolina as well has no children on site and no activation date as of December 8th. As far as unaccompanied children release date, the numbers are similar, down a little bit for the length of time in ORR care to 28 days as of November 3rd of 2023. The total number of unaccompanied children released to sponsors was at 113,495. As far as the top receiving counties for released children from ORR as of October 2023, Harris County was at 552 children, Dallas County second at 375, and Los Angeles County in California was at 343 and third. The top receiving states are also similar. Texas remains number one with 16,394 children released in 2023, California at 11,121, and Florida a close third at 10,542 children. So as far as changes in ORR policy, major updates include the significant incident reports. This was an implementation from ORR due to the report that was released by the Young Center in September of 2022. Major updates would include that care providers will no longer be asking for consent to refer a child to an LSP if the child falls into pre-screening categories, for example, sexual abuse, weapons threats, law enforcement involvement, etc. The referrals will be automatic, but they will be up to the child to disclose the nature of the referral to the LSP. Referrals to child advocates will be similar to the new process for LSPs. Other changes include that children aged 13 or younger or with a disability will be automatically referred to the LSP. LSPs also will not have access to behavioral notes from clinicians, except through the consent of the child. Subcategories of SIRs were streamlined, and this was, in fact, for the benefit of attorneys so that they can find exactly what they are looking for when they receive those referrals. It'll be easier to find the category. There will be specific template for LSP referrals, and the referrals will happen within a 48-hour window. SIRs post-release will now be called notifications of concern. Also, Field Guidance 25 was released on December 7th and provides guidance on the pilot program for verification of release. ACF is rolling out this program to selected programs beginning in 2024, January. This would provide all youth released from ORR care with an identification card like the one shown on the slide. The field guidance does not have information on which programs have been selected for this, but we will keep you posted. And there are upcoming changes to ORR's proposed rule to implement the Flores Settlement Agreement, which my colleague Dalia will discuss a little later in today's presentation. And we also wanted to share some news we recently received regarding the release of Unaccompanied Child Manual of Procedures by Health and Human Services and ACF. The manual, which contains 6 sections, was released as a result of litigation by Vecina and NILA. You can view the sections unredacted on NILA's website. We have provided the link here. Finally, the program listed as the Young Adult Case Management Program as a case management option on ICE's Alternatives to Detention page. It was launched in January of 2023. And many of you as advocates may have had one or more clients enrolled. It's the focus of a report linked here on the slide that is critical of the program and in its stated case management goals. ICE contracted with Acuity International to run this program, although it's not clear what the consequences would be for non-participation. But the program enrolls youth automatically when they've aged out and also includes youth who are stepped down from other alternatives to detention programs. And for those that are stepped down, the program removes the requirements for cell phones and other monitoring devices that are normally used by CBP. All right. Thank you all.
Thank you, Maria. My name is Laura Egan, and I'm a managing attorney at CILA. And next, we're going to go over some issues and updates related to Immigration Court, or the Executive Office for Immigration Review, EYR, and see what's been going on over the last year. So to get us started, we're going to go over the EYR backlog and some docket management tools. The backlog in Immigration Court has persisted, and more than 1.2 million cases have been added to the docket over the last fiscal year 2023. There are currently over 650 immigration judges and 68 immigration courts with 3 adjudication centers across the United States. But even with additional hiring over this last year, immigration courts across the country have struggled with very busy dockets. And with these busy dockets, there have also been several EYR docket management practices raised to try to help ease the load. So I'll go over a couple examples of those and what's been going on at Immigration Court. So one example are EYR specialized dockets. And so these are regarding straightforward cases. They might be stipulations, voluntary departure, adjustment of status, or just cases that are less complex. And then also off calendar notices. And these are cases that are being moved off of the docket because they're not ripe for adjudication. So EYR issues sometimes a notice of intent to take case off of court's calendar, and then they are removed from the docket unless a party files an opposition with a motion. And overall, it just seems like these docket management tools are impacting different courts in various ways, and it just depends on the judges, local practices. So it's impacting practitioners across the country, just depending on what's going on in their local courts. I also wanted to flag a proposed rule by EYR that was from September 2023, appellate procedures and decisional finality in immigration proceedings, administrative closure. So this proposed rule basically restores the regulatory text to reflect procedures that were in place prior to the prior administration's enjoined December 2020 final rule has the same name, appellate procedures and decisional finality in immigration proceedings, administrative closure. And so given the injunction on that, the proposed regulatory language really just reflects the current status quo. Dahlia is going to give some more information on this proposed rule later in the webinar. But overall, there's just more procedural options and mechanisms for judges to help manage their dockets in immigration court that have been in existence over the last couple of years. And sometimes that also does give advocates more tools for them to use as well to help their clients. So next we'll go over 2 key director's memoranda that are important to be aware of children's immigration work that were issued this past year. So the first DM is on language access in immigration court. This is DM 2302, and it was issued in June 2023. The purpose is to provide guidance to immigration judges on language access issues pertaining to immigration court proceedings. They did cancel a memo on contractor interpreter services with issuing this. But EYR must ensure that every non-citizen who appears before an immigration court has a full and fair opportunity to present their case. So for EYR to meet this objective, individuals with limited proficiency in English must be provided with in-court interpretation into their preferred language. This memo also discusses interpretation and translation services and access to these services. So it's an important one to be aware of because it comes up in much every case, or most, I will say. The second DM is 2303 on the role of child advocates. So this DM was issued in July 2023, and the purpose is to provide guidance to adjudicators on child advocates. They also canceled a prior on this issue, PM 2003. But under the 2008 TVPRA, a child advocate's role is to identify and advocate for the best interest of the child by making a best interest determination. So this memoranda discusses the history of child advocates, their role in immigration court proceedings, the purpose and content of best interest determinations, and procedures for considering a child advocate's input in a case. At the end of the memoranda, it emphasizes the importance of child advocates. So I just think that's a really helpful reminder as an advocacy tool, something you might want to point to in your advocacy, that the importance of child advocates is really emphasized at the beginning there. When practicing before immigration court, it's important to be able to navigate UR's website because there's a lot of important information. And so we wanted to highlight a few areas that I think have had some changes recently. And one very important space is UR's webpage regarding manuals and memoranda. So those DMs I mentioned, for example, it could be found by going here. Additionally, the Immigration Court Practice Manual, the BIA Manual, those resources live here and you can search for them. And, you know, those are important rule books and something you must be familiar with if you're in immigration court or if you're practicing before the BIA. So, you know, there were major updates to these manuals last year in 2022, but I think the look has just changed with the information being accessible from this webpage now for these living on this webpage now. And I also will just note there are pretty regular updates to these manuals, and it's always helpful to look at the table of changes to see the very latest edits to see what's happened more recently. As I mentioned, you can view all agency memoranda from this page. Also, UIR recently, or this past year, established an electronic reading room, redacted versions of unpublished BIA cases. So this can be accessed under the FOIA public access link page. So you can search for that from this web page, or you can find it and look for it under the additional reference materials, which is a section on the same page. The other web page I wanted to highlight on this slide is the Access EOIR initiative. So this was an initiative that was announced in September 2021, but it is an ongoing effort. The purpose is to provide respondents, representatives, and the general public with more direct access to agency and case information and the systems involved. So it has a whole lot of resources as well as some key links. And I'll give just a few examples. So some topics and information covered include information on how to request a record of proceeding, including in Spanish, introduction to immigration court video. There was a more recent notice from September 2023 on court filing assistance, and that says that UIR will help upload applications and documents for those who are not represented to ECAS and will provide a copy to DHS. So that notice is there and it's included in multiple languages. Also, for some of the key links, for example, it provides a link to the Immigration Court Online Resource, or ICOR, and the UIR Courts and Appeals System, or ECAS. So that's another helpful place if you're looking for something related to immigration court. The OCIJ staff directory is another resource on EOIR's website that has information per court. And on this slide, it's showing how you can navigate EOIR's website to find this directory and to search for it. But once you go there, the resource organizes information by state and then gives information per specific courts. So you can go to the court that you regularly practice before and find information, or if you're going to be going to a different court that you're unfamiliar with, it's a good starting place as well. So when you go to the individual court, that you want to view, you'll be able to see information regarding the location, the list of IJs, staff information, the court administrator, court clerks, and contact information. So you can see that from this page, it shows Minnesota as an example. This was something that was created for staff, but it's also a helpful resource for advocates. Now we'll get into some practice tips for EOIR. So WebEx hearings continue at EOIR, and as a reminder, DM 2207 on internet-based hearings says IJs must confirm that everyone appearing remotely is clearly visible on screen, and that all participants, whether appearing remotely or in the same location as the judge, can hear everything that's been said. So if there is an issue with visibility, or if facial expressions cannot be read, or if judges are off camera, those issues should be raised. In July, CILA hosted a CILA training on motions to rescind and absentia removal orders before the IJ and appeals to the BI and circuit courts. We also released an accompanying practice advisory on an absentia orders, and NILA issued template rescission motions on their website. So I recommend accessing these resources if these issues come up in your case. And we did include links to all of these in the handout. I also wanted to highlight a webinar that we did in February that was in conjunction with 2 prior immigration judges and 1 current immigration judge. We had a great candid discussion and a lot of tips and information related to children's immigration issues as well as pro bono. And, I think hearing from the judges themselves is always very helpful. They really did share a lot of great tips. So I recommend viewing that if you weren't able to watch it live. The next tip relates to EOIR Form 60 and 61 on limited appearance for document assistance. And so this relates to a rule that was issued in September 2022, but it had an impact in 2023. And EOIR has a helpful FAQ that was updated just this past summer in August 2023. That's a good resource to look to if you're working with these documents. CILA also has a blog post on this topic. And we've done some polling at working groups regarding the use of these forms, and they've been used very frequently by many for changes of address, changes of venue, motions to consolidate, and asylum workshops, for example. The next tip relates to pre-hearing conferences at EOIR. EOIR issued guidance on pre-hearing conferences in the summer of 2022, but in 2023, there were many stakeholder calls related to pre-hearing conferences. And really, they just are an opportunity to narrow the issues and limit testimony. So depending on where you are, depending on your case facts, they could be very helpful in children's immigration cases. And then, of course, just generally over the last couple of years, there's more procedural options when practicing before immigration courts. So it's important to consider all of those options when you're developing your case strategy. There are many times in children's cases, multiple steps that you need to go through. You might need to resolve different aspects of a case before USCIS or before state court before going before the immigration judge and resolving matters there. So consider all procedural options. And next, we're going to pass it to my colleague, Serena.
Thank you, Laura. Hi, everyone. My name is Serena Bhatia, and I am a senior staff attorney at CILA. I'm going to talk about prosecutorial discretion, or PD for short. So because there's so much that's happened over the last couple of years related to PD, we first wanted to provide a timeline of the main events that have occurred under this administration. So in September 2021, DHS Secretary Mayorkas issued a memo called the Civil Immigration Enforcement Priorities, also known as the Mayorkas Memo. In April 2022, the principal legal advisor at ICE, Carrie Doyle, issued a memo providing guidance to OPLA attorneys regarding the enforcement priorities and PD, and this memo is known as the Doyle Memo. The Doyle Memo heavily relied on the Mayorkas Memo in its guidance. Meanwhile, Texas and Louisiana sued in federal court to block the Mayorkas Memo, and in June 2022, a district court in Texas vacated the Mayorkas Memo. The case worked its way up to the Supreme Court, and while the case was pending, the Mayorkas Memo continued to be vacated. OPLA also stopped relying on the Doyle Memo in considering PD requests. Just a note that during this time, PD did not go away completely, only the reliance on these two memos did. OPLA always has an inherent authority to exercise prosecutorial discretion in individual cases. Now let's look at the positive developments that occurred during this past year. So on June 23rd, the Supreme Court issued a decision in the case US v. Texas, and the court determined that the states lacked standing to sue, and it reversed the district court's judgment, which had vacated the Mayorkas memo, meaning the Mayorkas memo went back into effect. Then on July 28th, OPLA then formally reinstated the Doyle memo. And on September 28th, EOIR issued Director's Memo 2304, which gives guidance to EOIR adjudicators on the enforcement priorities and exercises of prosecutorial discretion. Here are some resources about PD that have been published in the last few months, and they may be helpful for assessing the current climate of PD and also to learn about how to request PD in your practice. First, we have OPLA's frequently asked questions on the Doyle memo and PD. In September, OPLA updated their webpage, which provides a helpful overview of how their office is currently approaching PD. Then we have a practice advisory by NIP NLG. This resource describes the Biden administration's current PD policy in the wake of the Supreme Court decision, and it provides tips for practitioners advocating with DHS for PD on behalf of their clients. This practice advisory is an update of a previous practice advisory that was co-authored by NIP NLG and ILRC. Finally, we have an explainer on PD by NIJC. This resource provides information on dismissal and its ramifications for clients in removal proceedings. We'd like to provide some practice tips related to PD. First, keep requesting PD. We know it can take a while to hear back from OPLA, but keep at it, especially with the Mayorkas memo and Doyle memo back in effect. Second, for a deeper dive into the Supreme Court opinion in US v. Texas and deeper legal analysis, you can watch our CILA webinar from October called Litigation for Unaccompanied Children. This webinar is linked in the handout accompanying today's webinar. And finally, be creative with the form of PD that you request. We have heard of a practitioner who got ICE to cancel the NTA, meaning removal proceedings were never initiated. Another practitioner recently got OPLA to join a motion to reopen and rescind an in absentia removal order, which was a really big win for their client. So just keep at it and stay creative with your PD requests. With that, I will pass it to Victoria.
Thank you, Serena. I will now discuss special immigrant juvenile status and adjustment of status. There were a few SIJ and AOS application updates. The first one I'm going to discuss is the provision allowing applicants to apply in person before their 21st birthday. On March 30th, 2023, USCIS announced that SIJ petitioners or their legal representative can now schedule an appointment at their local USCIS field office to file their I-360 in person. The appointment must be within 2 weeks of the petitioner's 21st birthday, which, as we know, is the deadline to file for SIJ before USCIS. An appointment can be made by calling the USCIS customer service line and requesting an SIJ expedite appointment. Note that the person at the field office is not going to examine the application for completeness, and the application will be processed following the standard proceedings. If it's properly filed, the petitioner will receive a receipt notice with the date USCIS physically received the application at the field office. Then on November 8th, 2023, USCIS updated its guidance in the policy manual to align with the Casa Libre Freedom House versus Mayorkas declaratory judgment. The Casa Libre case is litigation out of California, where district court issued a DJ stating that the tolling provision outlined in DHS regulations are not in accordance with the 180-day time frame for adjudication of SIJ petitions as required by the SIJ statute. The March 2022 SIJ regulations provided that the 180-day time frame would restart when USCIS issued an initial RFE. It then restarts again when USCIS receives the evidence requested. Any subsequent RFE would stop the time frame, and then it would not restart again until the evidence was received. On July 31st, the U.S. District Court for the Central District of California issued a declaratory judgment that the 180-day adjudicatory timeframe is not restarted if USCIS requests initial evidence, and it's not suspended if USCIS requests additional evidence. So USCIS has updated its policy manual to align with this new order, and the update is contained in volume 6 of the policy manual and became effective immediately. Next, on March 31st, 2023, USCIS announced that they were removing the requirement that civil surgeons sign the Form I-693 medical report and vaccination record no more than 60 days before an individual applies for an underlying immigration benefit, including the I-45 adjustment of status. The policy update allows USCIS to adjudicate cases with medical exams that were not signed within the 60 days of filing instead of issuing an RFE. USCIS will now accepts medical exams for adjudicative purposes for up to 2 years after the date the civil surgeon signed the form. So it's good news, hopefully making all these adjustment filings easier. The 60-day rule was intended to enhance operational efficiency, but in the end it didn't happen. It confused people, and it turned out that many RFEs were sent out for otherwise valid medical exams. Lastly, also on March 31st, USCIS updated its policy manual to clarify that effective immediately, it would accept the self-identified gender marker for individuals requesting benefits. The gender marker they select does not need to match the gender marker indicated on supporting documentation, such as a birth certificate. The update also clarified that those requesting immigration benefits do not need to submit proof of their gender identity when submitting a request to change their gender marker. And there was also, it was also mentioned that DHS is working on an option to include additional gender marker X for another or unspecified gender identity. As of now, the only markers are male and female. Now let's talk about some visa bulletin changes that I'm sure many of you are aware of. That on March 22nd, the Department of State released the April 2023 visa bulletin, where it announced a change in interpretation on how it's going to allocate the EB-4 visas for applicants from Central America. These changes were reflected in the April 23 visa bulletin to correct the misapplication of law in prior visa bulletins. So for background, youth who have the approved SIJ frequently must wait years for their priority date to be current in order to apply for adjustment. The change in interpretation impacts the time the youth will wait for the PD to become current. So beginning in May of 2016, the Department of State applied a 7% per country limit for applicants from Central America. However, now stated as now the Department of State says that contravenes the department's current interpretation of the statutory prerequisite. So as a result, the new visa bulletin, in the April 2023 visa bulletin, those from El Salvador, Guatemala, and Honduras seeking a visa from EB-4 should look at the all chargeabilities areas except those listed column in charts for the final action date and filing dates that represent the rest of the world from those countries specifically listed. The change in interpretation will move, there'll be some forward movement for children from Central America, and then visa retrogression from youth from other countries. And we'll finish off with some practice tips. The first one is USCIS now has a new online change of address tool that was launched in October of 2023, and it allows individuals with pending applications to update their address more easily instead of having to mail the AR-11 or calling the customer service line or mailing a letter to the asylum office. It can all be done online at once. There are exceptions, though. Online change of address cannot be done for VAWA UNT cases. And this is also used by permanent residents who must notify USCIS that they've moved. Next, timeframes for paper filings. And I think this is just something that needed to be cleared up when it comes to deadlines and receipting. So if you have a deadline to file something, perhaps somebody's aging out, or you have an RFE deadline, if that deadline falls on a weekend or a holiday, it will be considered timely filed. Because it's going to, even if it's received the next business day. So USCIS will consider it timely filed, even though it's the day or the next business day after the deadline, if it falls on a weekend or holiday. The other one is another tool that we hope really does help advocates. It's that now folks can reschedule biometrics online. And in June of 2023, USCIS launched this online tool. If you have a biometrics appointment that needs to be rescheduled, no longer have to call the customer service line, although you still can if you want to. You can do it all online, request a new appointment for your client. However, this cannot be used if you're going to reschedule an appointment if it's already been rescheduled more than twice, or if the appointment is within 12 hours, or if the appointment has already passed. So if your client has missed their biometrics appointment, you won't be able to reschedule it online. You'll have to call, and you also have to show good cause for missing the appointment. And there's guidance on the USCIS website. And then stateless non-citizens. This is our last thing I just want to cover quickly. There might be some instances where you have an unaccompanied child that does not have a birth certificate for various reasons. Perhaps they were abandoned at birth, nothing was ever registered. You've tried with the consulate to get a birth certificate or some sort of identification. And USCIS has published policy manual guidance that applies to stateless non-citizens who are interested in filing for immigration benefits. I've linked resources. We have it to the handout. So if you have a situation like that where you're working with someone who may be stateless, there is guidance now that they might be able to help, and they could access immigration benefits. And with that, I pass it back to Serena.
Thanks, Victoria. I'm back now to go over updates related to crime and trafficking survivors. So in April 2023, USCIS updated its safe address policy, which has to do with mailing address and case handling procedures for VAWA, UNT visa petitioners. It was originally planned to become effective in July. However, USCIS recently issued an alert that the effective date for this policy has changed, and they now anticipate that this policy will become effective on or before March 29th, 2024. On January 13th, DHS announced a new process called Deferred Action for Labor Enforcement, known as DALE. This is a streamlined and expedited process through which non-citizens who experience or witness violations of labor rights can request deferred action. Deferred action through this process would provide temporary protection from deportation as well as eligibility for a work permit. NIP NLG created a resource that answers frequently asked questions related to DALE. This resource provides an overview of the process as well as practical considerations to keep in mind. And then in August, USCIS updated the policy manual regarding the EAD policy for qualifying family members of U visa petitioners. So the previous policy was that qualifying family members were not able to obtain an EAD until the principal petitioner first received an EAD through the bona fide determination process. Now the principal petitioner is no longer required to file the I-765 in order for qualifying family members to be considered for a bona fide determination and an EAD. I'll just give it a second. There we go. Yeah, we're on the right slide. And I think we're good for the next slide now. Moving on to VAWA updates, or Violence Against Women's Act, which provides relief to abused spouses, children, and parents. The new interpretation of the shared residence requirement, which was adopted by USCIS in 2022, remains in effect. So it requires a self-petitioner to reside or have resided with the alleged abuser at any time in the past. The prior interpretation required that shared residence to occur during the qualifying relationship. And then as of February 10th, VAWA self-petitioners must file their I-360 and I-485 at the Nebraska Service Center instead of the Vermont Service Center. Note that this is for VAWA only, and CIGIS petitioners should continue to file their petitions according to the appropriate address listed on the USCIS filing locations webpage. And closing with some practice tips for working with survivors of crime and trafficking. So we would encourage you to review the updated UNT visa law enforcement guides. They were both updated by USCIS in May 2022 in order to provide guidance to law enforcement agencies across the country that complete and work on the certifications for these forms of relief. You can provide these guides as resources to the law enforcement officials that you're communicating with or working with if they're new to this process. You can also use these guides as a resource for yourself because they can be really helpful in your own practice to ensure that the certifications that you receive from the law enforcement agencies are meeting all of the requirements set out by USCIS. We also encourage you to screen clients for DALE eligibility in trafficking cases and vice versa. And as a reminder, you can reference NIP NLG's resource on this process for more information about eligibility as well as practice tips. And then finally, we encourage you to rescreen clients for eligibility for different forms of relief throughout the life of their case. Since cases now remain pending for many, many years, eligibility can change and new forms of relief may become an option. So in light of that, CILA also has an ongoing series of blog posts on rescreening clients for relief, which again is linked in the handout. With that, I will pass it to Marisa to provide the CLE code.
Thank you, Marisa. And I'm going to get us started. My name is Amelia Friedman, and I'm a staff attorney in the Houston office. And we're going to next turn to asylum and border issues. So looking first at asylum, and we wanted to highlight some positive developments for seeking employment authorization for those who are using category C8, which is the category for pending asylum applications or applications for withholding of removal. First, in January, USCIS began announcing that they would be accepting applications online for the form I-765, which is great. And then in September, it was announced that the maximum validity period, meaning the amount of time that the employment authorization can remain valid, has been increased to 5 years for this category. And then most recently in October, USCIS announced that the 180-day automatic extension for renewals using the I-765 form would now be applying for category C8, which means that those who timely submit their application for renewal before the current employment authorization expires and of course are eligible for renewal should be able to qualify for this 180-day automatic extension window during this time period. In addition, we wanted to highlight some other updates from USCIS related to the asylum application process, and this has to do with what to do if you have a client who is in removal proceedings and their case is dismissed by EOIR. In October, USCIS provided some specific guidance on this, and as explained in the slide, if there is no application pending for asylum at the time the case is dismissed, the applicant can, of course, go ahead and submit a new application to USCIS, and it should be submitted to the lockbox in the jurisdiction where the person is located. And the receipt notice should use, similar to any new application with an I-589, the current filing date that it was submitted. If you have in a situation where somebody had already filed an application for asylum with the immigration court before the case was dismissed, the guidance says that they should go ahead and submit that I-589 to the USCIS lockbox, and then include a copy of the termination or dismissal order, proof that this application had been pending in immigration court when the case was dismissed, and any updated or additional information about the claim. The receipt notice from USCIS in this situation should show the original filing date, meaning when the application had been filed in immigration court. When we're talking specifically about unaccompanied children, there's another situation that can arise here, and that is, of course, unaccompanied children's cases. Jurisdiction can reside with USCIS to hear their asylum application even when they're in removal proceedings. So it's possible that when their case is dismissed, they already have a pending application with USCIS. In that situation, USCIS should retain jurisdiction, although it is encouraged to notify USCIS that the case with EOIR has been dismissed, and you can take that opportunity as well to kind of remind them of the pending application and provide any updates for their asylum application. It's also possible that USCIS may have referred a previously filed I-589 that remained pending in immigration court back to EOIR. And in those situations, if a new application is filed with USCIS, the expectation is that USCIS will issue a new discretionary notice to appear and send your application back to EOIR. So just something important to keep in mind that is unique to working with unaccompanied children. Finally, we kind of wanted to go over some asylum practice tips. As I think everybody is probably aware, the government declared the end of the COVID-19 pandemic this year, and with that, USCIS ended some of their COVID-19 flexibilities. That included a policy that had automatically extended certain deadlines, and so that has been over since March. In addition, they reverted back to their policy of requiring asylum applicants to bring an interpreter to their interviews. So that policy has been in place since September. I also wanted to highlight that with this new announcement in October about the extension, the automatic extension of employment authorization renewals, the guidance from USCIS does specifically state how somebody might be able to show that they are eligible in this kind of 180-day window. And it specifically says that they can use the 797 notice and their existing employment authorization to show eligibility, and that the notice should hopefully say that they are qualifying for this 180-day extension during the renewal. A couple other practice tips that are hopefully going to pop up soon, but related to the application for I-589. First, USCIS announced earlier this year that they have, as of July or as of this summer, they will only be accepting the most recent version of the I-589 application form dated in March. So just make sure you're using the correct form when applying for asylum now. There were also some updates to the instructions, and so if you haven't filed for a while, it's encouraged to kind of review those. In general, these were positive changes in that they clarified what documentation would need to be submitted with the I-589, and you're no longer required to submit multiple copies of certain documentation, and you're also no longer required to submit passport photos. Finally, there were some changes this year related to temporary forms of relief, and here we're looking at parole and TPS. And in general, the Biden administration has been offering more of these types of forms of relief available and been announcing them for different countries. The types of relief tend to be tied to the country of origin where the person was from. And in general, parole means that the person is applying for the form of relief before they arrive in the US when they're still outside the country, whereas temporary protective status is generally available to people inside the country. These are, just keep in mind, different from asylum in that they don't typically provide a pathway to citizenship, but they can be a way for somebody to legally be in the United States and to seek employment authorization. And one program in particular that we wanted to highlight is the Central American Minors, or the CAM program. And the resources handout that I believe was shared in advance of the presentation and will be also after has a great resource in it if this is something that you might be considering about how to apply, and it provides more details. But keep in mind that this program has been around since 2014, but the eligibility for it was expanded this year. And so this is for children who are located in Central America, El Salvador, Honduras, or Guatemala, and a parent who is located in the United States is seeking to be reunified with them. So if that's a situation that may apply to you, we encourage you to check it out. And with that, I will turn it over to Laura to talk about some border issues.
Thank you so much, Amelia. Super helpful information. There have been some major updates related to border processing and issues surrounding the border. This has been a major issue in the news. And so even if these issues haven't all been directly applicable to unaccompanied children, many times they do impact them indirectly. So we wanted to cover just a couple highlights. This is not comprehensive. Title 42 began under the Trump administration in March 2020 by CDC public health order during the start of COVID-19, and it has been used as a border management tool to effectively deny access to individuals seeking protection at the border. More than 2.8 million people were expelled while Title 42 was in place. Human Rights First and others have documented a lot of the dire situations people experienced, terrible conditions, violations, and other harms suffered. But this past year, the Biden administration announced in January that the COVID-19 public health emergency would end on May 11th, 2023, and then Title 42 would end then as well. With that end, DHS provided information on the related impacts of stopping Title 42 and announced several initiatives. One of those initiatives was the DHS and EOIR rule on circumvention of lawful pathways, which went into effect on May 11th, 2023. The rule applies to asylum seekers who enter the United States on or after May 11th, and the rule is supposed to last for 24 months. Overall, the rule severely limits opportunities for individuals to seek asylum at the border. Notably, the rule does not apply to unaccompanied children, so that's a notable exemption. There is ongoing litigation challenging the rule and seeking to stop enforcement. In October 2023, the U.S. reached a settlement in the Miss L versus ICE class action litigation, which was filed in 2018. And this was seeking injunctive relief relating to the separation of parents and children at the southwest border. The settlement was just finalized last week with the judge's approval and went into effect this week on December 11th. Approximately 4,500 to 5,000 children and their parents will be covered under the settlement, and the government is continuing to identify family members that were separated to fund their reunification in the United States and to provide a pathway for them to seek asylum here. Also under the settlement, families will have access to benefits to help get them on their feet, like work authorization, housing, legal assistance, and medical services. The government is also barred from reenacting the zero tolerance policy for the next 8 years. Those who do believe that they are class members can go to the Family Reunification Task Force's website and see more information on how to indicate that they're members. We do include helpful links in the handout regarding each of these topics. And that's it for asylum and border processing. I'm going to pass it to my colleague, Dahlia.
Hi, everyone. My name is Dahlia Castillo-Granados, and I'm the director at CILA. And I'll be giving an overview of some policy and advocacy updates. First, I'll start with an update from the End SIJS Backlog Coalition. The coalition is a national group of impacted youth and allied advocates that exists to educate Congress, relevant administrative agencies, and the public about the harmful impacts of visa caps on special immigrant juveniles and to advocate for an end to the backlog. I am one of 7 members of the Coalition Steering Committee, and the coalition is housed at the National Immigration Project. In a legislative win, the Protect Vulnerable Immigrant Youth Act was reintroduced in the House by Representative Gomez and others, It was introduced for the first time in the Senate by Senator Cortez Masto. The bill calls for the exemption of SIJs from the numerical limitations found in the employment-based fourth preference category where SIJs and other special immigrant categories are placed. The ABA president provided a letter in support of the bill. The backlog will not end without a legislative fix, and Congress will need to pass this bill or similar legislation to make that a reality. In the meantime, the coalition continues to work on educating Congress and the public about the harmful effects of the SIJS backlog. A new report by the coalition and Tulane Law's Immigrant Rights Clinic highlights new data obtained from USCIS through a Freedom of Information Act request and lawsuit. As of March 2023, 107,693 youth with an approved SIJS petition were waiting for a visa to become available so that they may apply for lawful permanent residence. Impacted youth come from 151 countries and live in all 50 states, with the top states being New York, California, and Maryland. The data also shows that the average wait time for USCIS to adjudicate an SIJS petition in fiscal year 2023 was 263 days, in violation of the 180-day deadline set out by the statute. Importantly, the report also features the story of SIJS youth who share how the backlog has impacted their lives. You can find more information about the report in a blog post on CILA's website. And for a deeper dive into the data, the authors of the report, Rachel Davidson and Layla Halas, wrote a law review article titled "The Double Exclusion of Immigrant Youth." The coalition also works to advocate with administrative agencies. This year, the coalition updated its frequently asked questions document on SIJS deferred action. Additionally, the coalition issued a practice alert on the Department of State's reinterpretation of the statute regarding the country cap and how it applies to the EB4 category, and a practice advisory on the reinterpretation's impact for youth with a removal order. In a new advocacy effort, the coalition sent a memo and followed up with a sign-on letter to the Department of Education to request that they extend federal student aid eligibility to SIJs. The coalition believes that SIJs meet the criteria in the Higher Education Act, and the department only needs to amend the Federal Student Aid Handbook to extend that eligibility. The coalition continues to advocate with USCIS, ICE, and UIR to alleviate some of the harms caused by the SIJS backlog. Coalition members have met with USCIS and ICE officials to discuss some of the coalition's advocacy recommendations. USCIS now has an FAQ on their website with responses to some of the questions submitted by the coalition. Finally, the coalition values the important contributions from directly impacted SIJS youth. A youth organizer, Alejandra Cruz, was hired by the coalition in August. Impacted youth can sign up to be part of the coalition by going to the web page here on the screen, and resources for youth are also available here. Next, I'm going to cover 4 proposed rules that were issued this year. They all affect unaccompanied children, and so far, none of the proposed rules have been finalized. Many of these proposed rules are redos from rules that were issued by the previous administration. If you're unfamiliar with the rulemaking process, this is the policy-making process for the agencies of the federal government. The agency issues a proposed rule or regulation and must provide the public with an opportunity to comment on the proposed rule. The agency then goes back to consider the comments, make changes, and finalize the rule. The most recent proposed rule is the Unaccompanied Children Program Foundational Rule. This rule was published on October 4th and comments closed on December 4th. The Office of Refugee Resettlement within the Department of Health and Human Services issued the proposed rule. The rule would implement the 1997 settlement agreement. The Florida Settlement Agreement provides that it will terminate 45 days after the publication of the final regulations. So this rule would terminate the Florida Settlement Agreement as it relates to ORR, but not to the provisions that relate to the Department of Homeland Security. The proposed rule goes through the history and background of the Unaccompanied Children's Program. It also describes the 2019 final rule on the Unaccompanied Children's Program, which included provisions that relates to both CHS and HHS. That regulation was litigated in 2 different lawsuits. And as part of the settlement agreement in one of the cases, HHS agreed to engage in new rulemaking. So this new rule would supersede the 2019 final rule. The proposed rule covers policies and requirements for the placement, care, and services to unaccompanied children who have been referred to ORR. The proposed rule defines specific terms, describes the process for referral and placement of unaccompanied children, and outlines policies and procedures for the release of unaccompanied children. It also outlines the requirements for when unaccompanied children are in custody, the transportation of children, the data collected from children, and guidelines for transfer within facilities. It also sets provisions for determining age, describes procedures for emergency and influx facilities, goes through the review process for ORR decisions, and establishes a UC Office of the Ombuds. Several organizations, including the ABA, submitted comments to the proposed rule. One noted area of concern is a lack of clarity regarding the Florida Settlement Agreement's requirement that facilities be state licensed. 2 states, Texas and Florida, no longer provide state licensing to ORR facilities. Another proposed rule on a federal licensing scheme is expected early next year. Another proposed rule, as mentioned by Laura, was issued by the Executive Office for Immigration Review within the Department of Justice. The proposed rule was published in early September, and comments were due by November 7th. This rule supersedes a previous final rule issued in December 2020. That rule limited the authority of immigration judges and the Board of Immigration Appeals to manage their dockets and dispose of cases. The rule was enjoined in March 2021, and the department decided to move forward with new rulemaking that would restore longstanding procedures by EOIR. The proposed rule covers briefing schedules changes before the BIA, administrative closure authority, termination and dismissal, and sua sponte reopening or reconsideration, and other procedural issues before the board. The proposed rule defines an unaccompanied child to match the federal definition, allows for voluntary termination of an unaccompanied child's case if they will first be seeking asylum before the asylum office, and it also implicitly allows for administrative closure for SIJS youth. Both the ABA and the End SIJS Backlog Coalition submitted comments with recommendations for stronger protections for immigrant children. The next proposed rule was issued by the Centers for Medicare and Medicaid Services within the Department of Health and Human Services. The proposed rule clarifies and updates definitions used for enrollment in several federal health programs. The rule would change the definition of who is considered lawfully present for eligibility under the Affordable Care Act and Medicaid and CHIP. The most significant change is removing an exception that excludes DACA recipients. Importantly, for unaccompanied children, there is a slight change in the definition for access to Medicaid and CHIP in states that elect to cover lawfully residing children. Currently, those with a pending petition for SIJS qualify, and the proposed rule would expand the definition to include SIJs with approved petitions. The definition for lawfully present individuals, which gives access to other federal health programs, would also be amended to include those with approved SIJS petitions. This rule was supposed to go into effect in November, but has not been finalized yet. One thing to note is that other individuals that are covered by the current definition of lawfully present include those with pending asylum applications, those with a pending adjustment application, and those with deferred action. The End SIJS Backlog Coalition submitted a comment in support of the proposed rule. The last proposed rule that I'll discuss today was issued by USCIS within the Department of Homeland Security. The proposed rule makes changes to the fees for certain immigration benefit requests. The proposed rule was issued in early 2023, and comments closed in mid-March. This rule proposes to replace a 2020 fee rule that was preliminarily enjoined before going into effect. The proposed rule increases the fees for certain petitions and applications, but also adds new fee exemptions for certain humanitarian programs. USCIS proposes to automatically exempt SIJs for all fees through final adjudication of the adjustment of status application. This means a fee waiver would no longer be necessary. The End SIJS Backlog Coalition submitted a comment in support with the request to clarify that the exemption includes the employment authorization application through deferred action. And finally, there are two pieces of legislation to watch. The first is the WISE Act of 2023, which was reintroduced by Representative Jayapal and supported by several Democratic House members. The bill makes significant improvements for immigrant survivors who apply for VAWA, U visas, T visas, and SIJS. Importantly, it exempts SIJs from the numerical limitations in the EB4 category, like the Protect Vulnerable Immigrant Youth Act. It also lifts the U visa caps, provides protection from detention and removal for survivors, and ensures that survivors have access to employment authorizations once they obtain protection and even before. The End SIJS Backlog Coalition has endorsed the bill. And the Immigration Court Efficiency and Children's Court Act of 2023 is a bipartisan bill introduced by Senator Bennett and co-sponsored by Senator Murkowski. It would create a specialized docket for unaccompanied children that requires experience and training for judges and ICE attorneys that handle children's cases. It also requires that judges work with local legal service providers to increase the representation of unaccompanied children. The bill is endorsed by the ABA. And now I'll turn it over to my colleague.
Thank you, Dahlia, and thank you to the entire CILA team for your presentations. Also want to recognize Nadia and Yasmin, who are working so hard in the Q&A box and chat. Great job, everyone. So, were you all able to write everything down? Did you get everything we said? Just kidding. Aren't you glad that it's being recorded? So now let's take a deep breath, get comfy as I pass it to Marisa, who will guide us through a nice wind down and some reflection.
Wasn't 2023 very busy? Thank you, team, for rounding child immigration of 2023 for all of us. Hi, everyone. My name is Marisa Barrera. I'm a social worker here at CILA. I want to take a moment to emphasize that this year wasn't solely about the work. It's been equally about the unwavering dedication and life of all of you, the advocates. The tireless commitment, resilience, and passion each of you has brought to the table has not only impacted the lives of children and families, but have also woven a narrative of your own perseverance and dedication. Let's take this moment to honor not just the monumental strides in immigration work, but also the profound impact of your dedication on the lives of those who you serve in your own journey. With that in mind, I want to now shift our focus from advocating for others to advocating for ourselves. I want to invite all of you and encourage you to join me on a mindful exploration, a chance to look back at your unwavering dedication, acknowledging not only the triumphs, but also the challenges. I want you to take a moment to find a comfortable, quiet space to settle down. I'll give everyone a moment to do so. Once you have done so, please close your eyes or keep them open if that feels better for you. Let's take a deep, nourishing breath in through your nose, filling your lungs, and exhale slowly through your mouth, allowing yourself to relax deeper in the present moment. Let's try that again. In through your nose, filling your lungs, and exhale slowly through your mouth, allowing yourself to relax deeper into the present moment. Now let's reflect on the work you have accomplished, the significant victories and small wins. Embrace the moments of triumph, those instances where you made a difference. Maybe you reunited a family, maybe you had a win in court, or maybe you provided crucial support to a child in need. Recognize and honor the dedication and compassion that powered these achievements. Now acknowledge the challenges, the setbacks that shape your path. These moments aren't signs of defeat. They're opportunities for growth and resilience. Consider the lessons embedded within these challenges. What insights did they offer you? Perhaps they taught you the importance of perseverance, flexibility, or the need for self-compassion during adversity. Consider how you advocated for yourself during these challenging times. Did you establish boundaries to safeguard your well-being? Did you seek support when necessary? Take a moment to appreciate the ways you care for yourself during challenging times. As we transition into 2024, carry these lessons with you. Envision stepping into the new year. Picture it, enriched by the wisdom gained from 2023. How will you apply these lessons to become a better advocate for yourself in the coming year? Whether it involves setting clear boundaries, prioritizing self-care, or seeking and nurturing a strong support system. Envision navigating 2024 with a renewed lens. Recognize that caring for yourself enables you to better support others. Take a few moments to absorb this vision. Feel the strength and determination within as you embrace the opportunities for growth and self-advocacy in the year ahead. When you're ready, gently bring your awareness back to the present. Wiggle your fingers and toes, allowing yourself to reconnect with the surroundings. Open your eyes if they were closed, feeling grounded and prepared to move forward within a renewed determination and self-advocacy. Now that we have grounded ourselves and reflected on this year, let's explore how we can position ourselves for success in advocating for ourselves in the coming year. And I don't know about you, but have you noticed that sometimes the more we focus on eliminating stress, the more stressed we become? It is an irony that many of us fall into. But what if I told you that the key isn't about erasing stress entirely? It is about embracing it, understanding the nuances, and mastering how to manage it effectively. Too often, we abandon the path of self-care because it feels complicated. Many times, these complexities arise from the misconceptions and the misunderstandings about what self-care truly entails. And of course, this can lead many of us to adopt ineffective or harmful self-care practices. How about we take a moment to lasso and debunk some of these misconceptions together? The goal is to address them and dispel this myth. You can scan the QR code on your slide, or you could go to slido.com and insert the number on your slide. I'll give everyone a moment so we could debunk some of this myth. Okay. Our first question, self-care is a reward to ourselves. I'll give everyone a moment to put your answer. Okay, we can show. And the answer is false. Self-care should not be conditional upon one's accomplishments or achievements. It is an essential part of maintaining overall well-being and should be incorporated regularly, regardless of our accomplishments. Thank you. Our next question, please. Self-care should always feel good. Always feel good. Give everyone a moment. Yeah, we can show the answer. And that is false. That's not always the case. Self-care is probably not going to feel good, at least at the beginning. It's probably going to feel yucky, uncomfortable, even painful. And that is because self-care is about processing your fears, your insecurities, rejections. It's about being vulnerable with others, but most importantly, with yourself. Sometimes self-care involves challenging tasks like setting boundaries, facing uncomfortable truth, seeking professional help, or even scheduling that medical checkup that you have been dreading. Thank you. Next question, please. Self-soothing is reactive and offers short-term relief, while self-care is proactive and offers long-term relief. I'll give everyone a moment to think about that one. Okay, I can display the answer. And that is true. Yes, that is correct. Both are part of self-care. However, while self-soothing is crucial for immediate comfort, even for grounding, self-care goes deeper. It addresses root causes, and it fosters lasting change by cultivating habits and routines that support mental, emotional, and physical health. And now to our last statement. Self-care is only about taking care of your mental health. Give everyone a moment to think about that one. Okay, we already know. It is false. Self-care goes beyond mental health. We are complex beings, and there are many things that make us, right? Think of the things that make you, you. Self-care is caring for your mental and emotional needs, your physical needs, social needs, spiritual needs, practical needs, and intellectual needs. If you neglect one or some of those, or more than one, it can be difficult and it could make you feel unwell. Thank you. And now to our last slide. Can you move to the next slide? Yeah. I think we were behind one. Thank you. Now that we have cleared some of the misconceptions and explored the lessons learned, it's time to set our sights into the upcoming year, 2024. I want to encourage all of you to make an appointment with yourself and set intentions for 2024. Visualize embodying your intentions. How does this look for you? Remember to be kind to yourself and to celebrate your progress, even the small wins, and learn and grow from the setbacks. Thank you so much for all you do. You do make a difference, and they know it. Thank you so much, and I'll let Victoria close us out.
All right. Before we go, if you had something we covered today, any lingering questions, or maybe we didn't get to your question in the Q&A, or if you have case-specific questions, please submit a technical assistance request, and we'd be happy to provide additional guidance. For those of you, if you didn't know, CILA has recently launched a new membership model. It's completely free, and you can gain access to even more CILA resources. When you click on Become Member at the top of the banner of our website, you'll see the different membership options or colors. There are 4 membership colors: green, magenta, pink, and purple. And you can choose the membership that gives you the resources that best fit you in your practice. And you do not need to be an attorney to become a member. This is open to everyone who is in a nonprofit organization who provide legal services. When you click on Get Started, it'll lead you to our membership form, and there's also a View Membership Detail button on the site, and it has specific details about the resources available under each color. If you were previously a CILA advocate, perhaps you had access to our Texas State Court templates. You don't have to sign up. You have automatically been converted to a magenta membership. So no need to sign up to access, just use your login and password. Super easy. And if you want to change your membership color in the future, we can do that. Reach out to us. We also want to highlight where you can find some of those great resources that we highlighted throughout the slides, and we're also posted in the chat. Our website has a heading for social services, and our social work resources will remain available without membership so that you can share them with youth, your clients, any sponsors, and other advocates. Please feel free to do that. You can find them by clicking on the online resources on our social work page. And we have some great toolkits, and some of them are available in both English and Spanish. As a reminder, CILA hosts a pro bono platform called Pro Bono Matters for children facing deportation on our website. And the goal is to match more pro bono attorneys with organizations' cases so that more children and youth have legal representation. Check out the platform on the CILA website if you're interested in taking a pro bono case. And additionally, if you're at a nonprofit organization and are interested in posting children's cases that need pro bono representation, please email us at probono@abacila.org for information on that. And lastly, follow us on social media. We provide announcements and updates on trainings. If you're like me and have a huge flooded inbox with tons of messages from listserv, sometimes the CILA emails can get lost in the mix. And you might have missed a training or something. So follow us on socials and stay up to date with all our announcements, especially about new resources or trainings, our guidance, and any other events. You just go to our account and everything's there. You don't have to dig through all your emails. All right. Well, with that, we are at the end of our webinar. We value your feedback, so please complete the feedback survey and link in the chat. Please let us know how we did so we can continue to improve and bring you trainings and resources that you want to see. Thank you to everyone for joining us today, our last webinar of 2023. Happy holidays and see you all in the new year. Bye.